So, at first, let me give you a background of the Vishakha Guidelines 1997. In 1992, Phanbari Devi, a social worker employed under the Rajasthan government's Women's Development Program, tried to stop a child marriage in her village. In retaliation, she was gang raped by influential men from the village. She faced severe injustice as the police investigation was inadequate and the trial court acquitted the accused. At that time, India had no specific law dealing with sexual harassment at the workplace. Victims could only rely on general provisions of the Indian Penal Code, which were insufficient. So, in the Vishakha case, several women's rights organizations led by Vishakha filed a public interest litigation or the PIL before the Supreme Court, and they argued that sexual harassment at the workplace violated women's fundamental rights under Article 14, that is the right to equality, Article 15, prohibition of discrimination on the basis of sex, Article 19(1)(g), right to practice any profession, and Article 21, that is the right to life and personal liberty, including the right to live with dignity. The Supreme Court also relied on the Convention on the Elimination of All Forms of Discrimination Against Women, or the CEDAW, an international treaty ratified by India to frame guidelines in the absence of domestic legislation. And its outcome is that on 13th August 1997, the Supreme Court issued the Vishakha Guidelines, making it mandatory for all employers in both the public and private sectors to prevent and address sexual harassment at the workplace until Parliament enacted a law. And these guidelines later became the foundation of the POSH Act 2013, or the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. And these Vishakha guidelines remained the first comprehensive legal framework on the issue in India and remained in force until they were replaced by the POSH Act. And this begins with the regard of Supreme Court for the definition of human rights, which is mentioned in the Protection of Human Rights Act 1993 in the section 2D. And that says, human rights means the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. So in total there are 12 guidelines mentioned by the Supreme Court. And the first one is that it is the duty of the employer or the other responsible persons in the workplaces and other institutions. So it is being said that it is the duty of these employers to prevent or deter the commission of acts of sexual harassment in their workplace and to provide the procedures for the resolution, settlement or prosecution of acts of sexual harassment by taking all the steps required. And the second guideline has provided the definition for the sexual harassment at the workplace, and there are 5 conditions. That is, first one is that the physical contact and advances. Next one is a demand or request for sexual favors. The third one is sexually colored remarks. Fourth, showing pornography. And the fifth one is that any other unwelcome physical, verbal or non-verbal conduct of sexual nature. So these are the 5 acts explained by Supreme Court as the circumstance that can be humiliating and may constitute a health and safety problem inside the workplace where they work and seek the employment and salary. And the next or the third step is the preventive steps that should be taken by these employers or persons in charge of this workplace. So the first one in that is to express these definitions of sexual harassment at the workplace. This should be notified, published and circulated in appropriate ways. Second, under this preventive step is the rules, regulations of government and the public sector bodies relating to conduct and discipline should include these rules, and appropriate penalties should be imposed against the offender. And the third is towards the private employers. They should take appropriate steps to add these rules in their standing orders under the Industrial Employment Standing Orders Act of 1946. And the fourth is that appropriate work conditions should be provided in respect of the work, leisure, health and hygiene to ensure that there is no hostile environment towards women in workplace, and no employee woman should have the reasonable grounds to believe that she is in a disadvantaged position in connection with her employment. The fourth guideline is the criminal proceedings. If any such acts amount to a specific offence under the Indian Penal Code or under any other law, the employer shall initiate appropriate action in accordance with the law by making a complaint with the appropriate authority. Also, it should ensure that the victims or witnesses are not victimized or discriminated against while dealing with complaints of sexual harassment. And the victims of the sexual harassment should have the option to seek transfer of the perpetrator or thereon transfer. And the fifth guideline is the disciplinary action that should be initiated by the employer in accordance with the service rules. The sixth guideline is the complaint mechanism. So the employer should create a complaint mechanism inside the organization for redress of the complaint made by the victim. And also, such complaint mechanism should ensure time-bound treatment of complaints. This seventh guideline is a complaints committee. That is, a complaints committee, a special counselor or other support service including the maintenance of confidentiality should be set up under the complaint mechanism mentioned in the sixth guideline. The complaint committee should be headed by a woman and not less than half of its members should be women. Further, to prevent the possibility of any undue pressure or influence from senior levels, such complaints committee should involve a third party, either NGO or other body who is familiar with the issue of sexual harassment. That is, to prevent the possibility of any pressure from the senior level, they should also include a third party to the complaints committee. And the complaints committee must make an annual report to the government department concerned of the complaints and actions taken by them. So the eighth guideline is workers' initiative. That is, the employees should be allowed to raise issues of sexual harassment at a workers' meeting and in any other appropriate forum, and it should be affirmatively discussed in employer-employee meetings. The ninth guideline is the awareness, that is, the awareness of these rights of these female employees should be created in particular by prominently notifying the guidelines. So, this should be added as a guideline or given as a guideline in the companies so that the female employees will have the awareness of their rights. And the 10th guideline is the third party harassment. That is, whenever the harassment is from any third party or outsider, the employer and the person in charge should take all the steps necessary and reasonable to assist the affected person in terms of support and preventive action. The 11th guidelines is to the central or state government, that is, they are requested to consider adopting suitable measures including legislation to ensure that these guidelines that is laid on by the order of the Supreme Court are also observed by the employers in private sector. So, these central and state governments are made to enact laws to make sure that these guidelines provided by the Supreme Court are also observed by the employers in private sector. And the 12th guideline is that these guidelines will not prejudice any rights available under the Protection of Human Rights Act 1993. So these are the 12 guidelines issued by the Supreme Court in the Vishakha vs. State of Rajasthan 1997.